And indeed, this institution of hundreds may be traced back as far as the ancient Germans, from which were derived both the Franks who became masters of Gaul and the Saxons who settled in England. For we read in Tacitus that both the thing and the name were well known to that warlike people. Quote, Centeni ex singulis pagis sunt, itque ipsum inter suos vacantur, et quod primo numerus fuit, iam nomen et honor est. End quote. An indefinite number of these hundreds make up a county or shire. Shire is a Saxon word signifying a division, but a county, comitatus, is plainly derived from comis, the count of the Franks, that is, the earl or alderman, as the Saxons called him, of the shire, to whom the government of it was entrusted. This he usually exercised by his deputy, still called in Latin vicecomis, and in English the sheriff, shreve, or shire-reeve, signifying the officer of the shire, upon whom, by process of time, the civil administration of it is now totally devolved. In some counties, the officer of the shire, upon whom, by process of time, the civil administration of it is now totally devolved. In some counties, there is an intermediate division between the shire and the hundreds, as Leeds in Kent and Rapes in Sussex, each of them containing about 3 or 4 hundreds apiece. These had formerly had their laith reeves and rape reeves, acting in subordination to the shire reeve. Where a country is divided into 3 of these intermediate jurisdictions, they are called trythings, which were anciently governed by a trything reeve. These trythings still subsist in the large county of York, where, by an easy corruption, they are denominated ridings, the North, the East, and the West Riding. The number of counties in England and Wales have been different at different times. At present, there are 40 in England and 12 in Wales. 3 of these counties, Chester, Durham, and Lancaster, are called counties palatine. The 2 former are such by prescription, or immemorial custom, or at least as old as the Norman conquest. The latter was created by King Edward III in favor of Henry Plantagenet, first Earl and then Duke of Lancaster, whose heiress, John of Gant, the king's son, had married, and afterwards confirmed in Parliament, to honor John of Gant himself, whom, on the death of his father-in-law, he had also created Duke of Lancaster. Counties palatine are so called a pallatio, because of the towns thereof. The Earl of Chester, the Bishop of Durham, and the Duke of Lancaster had in those counties jura regalia, as fully as the king hath in his palace, regalem potestatem in omnibus, as Blackstone expresses it. They might pardon treasons, murders, and felonies. They appointed all judges and justices of the peace. All writs and indictments ran in their names, as in other counties in the king's, and all offences were said to be done against their peace, and not, as in other places, contra passem domini regis. And indeed, by the ancient law, in all peculiar jurisdictions, offences were said to be done against his peace in whose court they were tried. In a court leet, contra passem domini; in the court of a corporation, contra passem varivorum; in the sheriff's court, or torn, contra passem vice comitis. These palatine privileges were in all probability originally granted to the counties of Chester and Durham, because they bordered upon enemy countries, Wales and Scotland, in order that the owners, being encouraged by so large an authority, might be the more watchful in its defence, and that the inhabitants, having justice administered at home, might not be obliged to go out of the county, and leave it open to the enemy's incursions. And upon this account, also, there were formerly 2 other counties palatine, Pembrokeshire and Hexhamshire, the latter now united with Northumberland, but these were abolished by Parliament, the former in 27 Henry VIII, the latter in 14 Elizabeth, and in 27 Henry III. Likewise, the powers before mentioned of owners of counties palatine were abridged. The reason for their continuance in a manner ceasing, though still all writs are witnessed in their names, and all forfeitures for treason by the common law accrue to them. Of these three, the county of Durham is now the only one remaining in the hands of a subject, for the earldom of Chester, as Camden testifies, was united to the crown by Henry III, and has ever since given title to the king's eldest son. And the county palatine, or duchy, of Lancaster, was the property of Henry of Bolingbroke, the son of John of Gaunt, at the same time when he wrested the crown from King Richard II, and assumed the title of Henry IV. But he was too prudent to suffer this to be united to the crown, lest, if he lost one, he should lose the other also. For, as Plowden and Sir Edward Coke observed, quote, "He knew he had the duchy of Lancaster by sure and indefeasible title, but that his title to the crown was not so assured, for that after the decease of Richard II, the right of the crown was in the heir of Lionel Duke of Clarence, second son of Edward III, John of Gaunt, father to this Henry IV, being but the fourth son, and therefore he procured an act of Parliament, in the first year of his reign, to keep it distinct and separate from the crown, and so it descended to his son and grandson, Henry V and Henry VI. Henry VI being attained in 1 Edward IV, this duchy was declared in Parliament to have become forfeited to the crown, and at the same time an act was made to keep it still distinct and separate from the other inheritances of the crown, and in 1 Henry VII another act was made to vest the inheritance thereof in Henry VII and his heirs, and in this state, say Sir Edward Coke and Lambert, viz., in the natural heirs or posterity of Henry VII, did the right of the duchy remain in their days, a separate and distinct inheritance from that of the crown of England. The Isle of Ely is not a county palatine, though sometimes erroneously called so, but only a royal franchise, the bishop having, by grant of King Henry I, jura regalia within the Isle of Ely, and thereby he exercises a jurisdiction over all causes, as well criminal as civil. There are also counties corporate, which are certain cities and towns, some with more, some with less territory annexed to them, to which out of special grace and favour the kings of England have granted to be counties of themselves, and not to be comprised in any other county, but to be governed by their own sheriffs and other magistrates, so that no officers of the county at large have any power to intermeddle therein. Such are London, York, Bristol, Norwich, Coventry, and many others, and thus much of the country subject to the laws of England.